misdemeanor, they ought not to have, should not have, and would not have impeached. So there's no longer a question of impeachment. What is before us, what is the responsibility of the Senate? What does the Senate wish to do? And the question should be more, as that committee report indicates, should be more than merely determining how many votes of one party we have versus another. Do we have 67 votes? Well, we can only get 55. Well, that assumes that the process is entirely, extremely, and solely political. It is political, but then you have to contend with the fact that you've also taken the solemn oath to do justice impartially.
Now,
so that is the responsibility that is not yours nor mine. Very difficult.
But it raises many questions and many issues.
All before the body to whom it's been entrusted by the Constitution.
Because if the Senate voted specifically 55, Republicans for and 45 or 47 Democrats against, it would clearly appear to be something that wasn't reviewed by them based on their oath of office. Now,
and we know that will be final because these are not justiciable questions, as the Supreme Court has said. Some of the cases of the judges are absolutely fascinating. One judge was actually in jail after having been found guilty by a court of having committed a serious felony. And while in jail, he was still recovering, he was still receiving his judicial compensation. And that's because he had not yet been removed by impeachment. Then he was impeached, removed by impeachment, and, of course, having been removed from office, the compensation stopped.
You also mentioned that I think Judge Hastings was removed, and he later served in the House of Representatives.
Yes, I did. That is a very extremely interesting case where Judge Hastings was acquitted. No, he had been acquitted. And then the judicial body, the judicial council having jurisdiction over that particular judge, determined that there were facts there that warranted investigation whether he should be impeached. And he was impeached, and he was found guilty by the Senate, and he made a powerful personal appeal. He was found guilty and was removed. Interestingly enough, in that case, as in others, they did not use the body that impeached, that found him guilty of impeachment, did not use the second clause of the Constitution that says, and he will be disqualified from further office. They just said, he shall be removed.
So that's an optional clause, and
well, it's been so applied, but that's why I read the actual article pertaining to the present situation where the impeachment articles specifically provide for both.
The other part is it said all civil officers. So the impeachment process, I know we've used it with judges. We now
it includes judges.
With presidents.
Yes.
What other civil officers would it?
Well, it means that not. Well, it means it excludes military officers, for example. Military officers, and we don't, that's a separate topic, very important, are judged by a much more rigid standard. An officer may be punished and would lose his rank and sent to jail for conduct on becoming an officer and a gentleman. That was the old Articles of War, and even the Articles of War that are effective today. And there is conduct disorders to the prejudice of good order and military discipline. You go into a bar somewhere as an enlisted person, you're a sergeant, a corporal. Much more serious if you're an officer and you cause a rumpus, you cause a riot there, you cause a disturbance, you can be punished. You may lose your rank and you may go to jail.
Could it apply, for example, to a vice president? Yes.
No. No, unless the vice, no. Or impeachment.
Yes, impeachment.
Well, with that same standard. Well, that's the problem. The problem is, what is the standard? You see, now, the moment you talk about something else, you now say, well, to what extent is that analogy relevant? If we want to use a military analogy, and that is something that, of course, has been raised, that raises really difficult questions, because there you have a judgment that undoubtedly will be much more severe.
Could you use impeachment against a member of the cabinet?
No.
The president's cabinet. Is he a civil
also,
officer?
Absolutely, because even judges have been deemed to be civil officers, no question about that.
And then also senators, for that matter.
No. They're senators. They have the right to choose. They have the right to pass upon their own qualifications for office, and they also may expel. But you see, the more you talk, the more you see you are talking about matters, some of which are specifically covered by the Constitution.
Okay.
And that is the one contribution I should like to make, which was what I like to do and try to do with the lawyers to whom I spoke when you were in the audience, namely that please look at the constitutional provisions. What does it provide? What does it say? Because in all other things, the Senate has great power, but they cannot change the Constitution. That calls for a constitutional amendment.
One issue that was raised is, I think, a scholar, I think Floyd Abrams, on a First Amendment issue, requested that the proceedings be open to the public.
Well, all of that can be determined by Senate rules. The Senate is supreme in determining how that trial is going to be conducted. I referred to Rule 11 that says that, suppose the government was so, everyone was so concerned that so many judges, after only a few had been impeached over 100 or more years, all of a sudden, 1, 2, 3, 4, within a short period of time, that the president, pursuant to an act of Congress, a commission was appointed. And it's interesting that if you look at the commission that was recently appointed in the 90s, 92, 93, to pass upon what should we do about, there are so many judges. We now have many more federal judges, Article 3 judges, than we had in the past. Now there are almost 1,000, I believe. Should we have the work of the Senate stop? Of course, I've already mentioned Rule 11, but it's interesting that this National Commission of truly distinguished individuals decided to leave the Constitution alone. And they also would say that the Constitution has worked well with the judges, and it has worked well. So the amendment of the Constitution is in itself an even more serious thing. And they say within the framework of the existing Constitution, the impeachment provisions, surely with relation to the judges, has worked well. And you notice that they even recommend not amending it. This distinguished commission, their report, I think, was dated, I'll give you the date of the report. It's a very interesting modern report. The National Commission on Judicial Discipline and Removal, August 2nd, 1993. And they say that all of these questions stemming from this impeachment process are non-justiciable, which is precisely what the Supreme Court has said. As a matter of fact, I would recommend reading that report because I think it's a beautiful summary of what is the existing law.
In other words, the law was left open when the founders...
It was so intended by the founders. The founders knew that they wanted a separation of powers. They didn't want any branch, as it were, to become anything more than a co-equal branch, and this is the way they wanted to control the executive branch when the executive really abused its powers.
It's been fascinating in many ways. There are so many open questions that I think I'd like to ask. I'm wondering, you know, whether, for example, the issue of the members of the House have changed because of an election. What would happen in that type of proceeding? Let's say, since the impeachment may go over.
That shouldn't really, that question is of course excellent, but it really shouldn't surprise us. Is it not possible that two different juries would have come to a different conclusion if they heard the same case?
Yes. The answer.
You see, the answer is, and that's why I say you're asking me to guess what the court is going to find in your case, soldier. I'm sorry. If the court believes you, you will be acquitted. And if it doesn't, well, you know the answer to that one.
Even now, the House managers who were running the trial, I think almost all of them are Republicans. And that would, you know, it strikes me as
yes, but
something that...
they are Republicans, and the others are Democrats, but I'm not willing to make the inference that by virtue of that fact they will not do their constitutional duty responsibly in accordance with the requirements of the Constitution. That's a very difficult question, because I will not assume that a juror will vote a particular way necessarily because of a fact such as that, any more than I would because of race, color, creed, national origin. I'm still under an obligation, a solemn duty pursuant to my oath to do justice impartially.
What about...
It's interesting, the oath of the military is really wonderful. Without partiality, do you solemnly swear that you will do justice and according to the evidence, without words I want to quote, without partiality, favor, or affection? Those are interesting words. I recall we once had a meeting, a rather high-level meeting. Should we do away with the oath in courts martial? Of course, I voted against that. Should we add the nameplate onto the soldiers? I recall serving on all of these military commissions, even as a reservist. And it's amazing how that nameplate added to the responsibility. You weren't just a corporal, you were Corporal Jones, and that raised the responsibility of not disgracing, as it were, the uniform.
At one point, you mentioned that in law schools, frequently exams are graded without knowing the name of the student.
Oh yes, nowadays, and I think it's excellent, exams are graded anonymously. Of course, even long before the anonymous grading, we graded papers anonymously anyway. How? Well, you put your thumb, as it were, over the name. Because frankly, if you know the individual and you have affection for the individual, it isn't a question of disliking. My problem was one of knowing them and having affection for them. That might cause a bias in whether you should give 98 or 97 or 89 or 90. So the bias, the elimination of bias has made it easier to grade papers. Because you say, gee, I didn't fail you, Irwin, I failed this paper. All the things you've told me now show that you know the answer to the problem, but where did you say that here?
Another issue that came up is this started when Kenneth Starr, the special prosecutor, was investigating certain issues related to the president, his wife, his associates, and the office of the special prosecutor was relatively new. It was
pursuant to a statute. The thought was that we would have an independent counsel look into the matter to determine if there were facts that warranted impeachment, and if so, he would refer to the Judiciary Committee. They would determine if there was a basis for an inquiry. If there was an inquiry, there would be a resolution that we will investigate this seriously. And as a result of our investigation, have we found that there were high crimes and misdemeanors, if it wasn't treason or bribery, that would warrant a trial. So actually, a preliminary determination has been made. We speak of censure. Well, to the extent that it is relevant, it cannot be denied or negated that the House of Representatives has voted that these acts, in the opinion of those who looked into the facts, believe that they were committed. That person has not yet been found guilty because that requires a trial pursuant to the appropriate provisions of the Constitution. But the impeachment, of course, it means that there has been some finding. Now, in the case of the judges, that